If you represent a foreign government or foreign company doing business in the United States, or if your U.S. business has foreign clients, foreign investors, or other foreign ties, you should be aware of the Foreign Agents Registration Act, or FARA, and of the U.S. Department of Justice's upcoming revisions to FARA's exemptions. FARA is a broad and complex law that requires disclosure and transparency about foreign efforts to influence U.S. policy and public opinion. In the past few years, U.S. law enforcement and legislators have scrutinized foreign influence in American politics, commerce, and popular culture, with a current focus on sovereign wealth funds, litigation finance, news media, and social media. Suspected FARA violations can potentially lead to criminal prosecutions, civil lawsuits, and administrative inquiries by the Justice Department, as well as investigations by the U.S. Congress. As a result, U.S. operations by companies with foreign funding or other foreign control should integrate FARA into their corporate compliance programs. FARA requires that anyone who acts within the United States as the agent of a foreign principal must register with the Justice Department and comply with other record-keeping and reporting requirements, unless a statutory exemption applies. A foreign principal could be a foreign government or political party, but it could also be a foreign individual or entity with no government link at all, such as a private business or nonprofit organization. 4 kinds of activities trigger FARA when performed within the United States on behalf of a foreign principal. First, serving as a political consultant or public relations consultant. Second, soliciting or distributing funds or other things of value. Third, representing a foreign principal's interests before the federal government. And fourth, political activities. FARA defines political activities as efforts to influence either the federal government or any section of the American public about U.S. policies or the interests of foreign governments or political parties. The Justice Department broadly interprets political activities to include everything from traditional lobbying to corporate publicity campaigns to promoting U.S. investment and tourism in foreign countries, whether those activities target the federal government, state or local governments, the private sector, or members of the general public. Although FARA's scope is broad, it also exempts many legal, commercial, and other activities from registration. One important exemption is a catch-all provision that currently protects many foreign private companies who lobby the U.S. government for their own commercial interests. However, the Justice Department recently announced that it will revise and narrow this catch-all exemption. Depending on what the upcoming regulations say, it's possible that some foreign companies might need to start registering under FARA before they can lobby U.S. officials about their business needs. In recent years, the Justice Department has also devoted ever more time and resources to FARA investigations and pursuing criminal prosecutions and civil enforcement litigation. As a result, U.S. operations with foreign connections should familiarize themselves with FARA and whether the law applies to them. For more on FARA, please visit arnoldporter.com and stay tuned into our Critical Compliance series.